Hello and welcome to August's edition of HR Hot Topics. I'm your host, Jodi Schafer, and as always, we aim to make this the most informative 5 minutes of your month. So we're sitting here, it's the first part of August, and it's gorgeous outside. Summer's waning, and I'm counting down the days till school's back in session, and I thought it would be a good time to just bring a few updates to you all, because many of you are probably on vacation and you might view this later on. So there isn't anything time sensitive today, but wanted to give you an update on what's happening with Michigan minimum wage and paid sick leave. Yes, that issue is not dead, will not die, and I wanted to let you know the latest and greatest there. And then I also wanted to talk about a recent Department of Labor opinion letter as it has to do with rounding of time and kind of a good reminder for here in Michigan what our rules are and deductions that are permissible and not permissible. So that's kind of what we're going to talk about today. Let me start with the latest and greatest on minimum wage and paid sick leave. So as you'll recall, if you've been listening to these videos or following along on this issue, the minimum wage law and the paid sick leave law were actually born out of a citizen initiative. So a ballot proposal was kind of or a ballot initiative was put forth. And whenever a citizen initiative starts, you have to get a certain number of signatures by a certain timeline. And then if you reach those signatures by the timeline, your proposed law goes in front of the Michigan legislature, and they get to decide whether or not they want to adopt it as written. They can't make changes to it at that time, or whether they want to push it to the ballot and let voters decide. And in the case of minimum wage and paid sick leave, the legislature chose to adopt both of those initiatives as written. And this was earlier last year. And so in lame duck session at the tail end of last year, the Michigan legislature made significant changes to both of those pieces of legislation before they became effective in March. And there's been a lot of back and forth about the constitutionality of that decision by the legislature. Did they have the right to amend a piece of legislation that was initiated by a citizen ballot proposal in the same session in which it was adopted? And so this question certainly is going to be taken up in the courts, and sort of preemptively, the House and Senate have asked the Michigan Supreme Court to weigh in on this and just once and for all settle whether or not they had the right to do what they did. Now, the Michigan Constitution is silent on whether or not the legislature has the right to do this. And so, sort of up for interpretation. And so the Michigan Supreme Court agreed to hear oral arguments on this in July, this past July, so on the 17th. We don't know yet if they're actually going to issue an advisory opinion or not, but they have heard oral arguments. And so we're just waiting to see what happens again, right? So nothing has changed. You're still going to be complying with both of these amended laws as you would have in March, but I don't know what the future holds, and so just wanted to give you an update on there. And certainly as things progress, and if the Michigan Supreme Court does weigh in on this, you'll be the first to know. I'll make sure to send out some information on that. So that's the first one. The second thing that I just want to bring your attention to has to do with a recent Department of Labor opinion letter as it relates to the Fair Labor Standards Act, so how we pay our employees. At the federal level, it is permissible to round hourly employee pay to the nearest 5-minute, 10-minute, 15-minute, or 30-minute increment, so long as the rounding doesn't hurt the employee. So you kind of have to look on the surface. Sometimes it's in the employer's favor, sometimes it's in the employee's favor. And as long as that all works out, the Department of Labor reaffirmed that, yes, that's fine. But what I want to call your attention to is that while on the federal level, you may be able to round in increments up to 30, in Michigan, we have different rules. So the Michigan wage and hour law only allows you to round up to the nearest 10th of an hour. So 6-minute increments. That's the maximum amount of time you can round an hourly employee's pay unless you have a collective bargaining agreement that says otherwise. So for those of you that are rounding to the nearest 15-minute mark and all's good and the employees are good with that, you may be running afoul of our state law in that area. So I'm going to encourage all of you to take a look at your rounding practices. Make sure that you're not rounding in more than 6-minute increments if you're working in Michigan. The second piece, and this has to do again with pay practices in Michigan, is that you can't deduct from an employee's pay for things that are disciplinary in nature. So I've read some handbooks where a client will say, look, if you show up late, even if it's 2 minutes late, I'm going to dock you 15 minutes of pay. In Michigan, you can't do that. You have to pay for all hours actually worked. Or, you broke this piece of equipment. I'm going to take that out of your paycheck. You can't do that unless the employee agrees to the deduction voluntarily at the time of the deduction, and the deduction's not going to drop them below minimum wage. So just be careful about things you're taking out of people's paychecks. Make sure that you can legally do so. Again, this is a Michigan statute, Michigan wage and hour law here. And if you are making deductions for things other than taxes, insurance benefits, and wage garnishments, that you have a signed authorization from the employee to do so. So with that, I'll leave you to the rest of your summer. Please enjoy this warm weather and what's left of it. If you have any questions, you can reach me at Jodi Schafer at workwithhrm.com. We'll see you next month.